Good morning, everyone. As part of the new normal, I'm going to upload my lectures on this YouTube channel. So to start with, we are going to discuss the law on partnership. Let me share my screen. Okay, the law on partnership. So for this particular YouTube episode, we are going to discuss about the definition of partnership, and also we have to answer the question, when does partnership commence to exist? What are the formalities required in the formation of a partnership? What are the elements of a partnership? What are the essential features of a partnership? And lastly, we will distinguish between partnership and co-ownership, and a partnership and a conjugal partnership of gains. We start by the definition of partnership in accordance with Article 1767 of the Civil Code. Article 1767 provides that by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Two or more persons may also form a partnership for the exercise of a profession. From the definition given to you by Article 1767, you will take note that a partnership by nature is a contract. When you say that a partnership by nature is a contract, that means that first and foremost, a partnership is a form of contract. Which is why, class, you will take note that one of the essential features of partnership is that it is a consensual contract. It is a nominate contract, which gives you the idea that a partnership is a form or a special species of a contract. Okay? Now, in this contract, now you will take note that the party to a contract of partnership is consisting of two or more persons. Now, a single person may not form a partnership because the law requires the minimum number of partners, which is two. Okay? Now, in this contract of partnership, the parties to the contract or the partners themselves will have to contribute three things. Now, what are these three things? Number one, money. Number two, property. Or number three, industry. No, what I call as MPI, money, property, or industry. You will take note that the capital contribution or the contribution of a partner will give you the classification of a partner. What do I mean by this? For example, that if you have contribute money or property, you will be considered or classified by law as a capital partner. Now, on the other hand, if the contribution of a partner consists of labor or service, then you will be classified by law as an industrial partner. Now, these contributions made by the partners will have to form a common fund. This common fund class will consist of the assets of the partnership. When you say assets of the partnership, there will be a co-ownership between the partners as to the entire assets of the partnership. When you say common fund or co-ownership, that means that each partner cannot point to a specific property which he or she owns. By the time that the partner will contribute his money or property, then such money or property will form part of the common fund or the assets of the partnership. Now, each partner will have to own the entire assets of the partnership. And again, I have to emphasize that a partner cannot point to a specific property that he contributed as his own or separate property. Once you have contributed such money or property, that asset will now form part of the common fund, which is co-owned by the partners. Now, the most important element of a contract of partnership is the intention of the parties to divide the profits among themselves. Okay, so since there has been a contribution in the form of money, property, or industry pursuant to the business of the partnership, no? When the partnership transacts or conducts its business, the corresponding yields or profits will have to be divided by the partners themselves. Now, this is the first form of partnership in accordance with Article 1767. Now, another form of partnership is not for the purpose of transacting a business, but for the exercise of a profession. Because technically, class, the exercise of a profession is not a business endeavor. It is not a business transaction, which is why the law will have to delineate these two types of partnership. No, the second form of partnership is a partnership for the exercise of a profession, or what you can see in the textbook as a professional partnership. What do we mean by professional partnership? These are persons who are qualified to perform a certain profession and that they have formed a partnership in order for them to what? To practice the profession as a firm. For example, class, a law firm which consists of duly authorized lawyers who are authorized to practice law in the Philippines. Now, if this lawyer will form a group which will be called by law as professional partnership, then there will also be some contribution in the form of money, property, or industry to the assets of the such a professional partnership. And for example, class, the Association of Certified Public Accountants, there are certain accounting firm. For example, in Makati, no, if this group of CPAs will form a group, then that group will be called as a professional partnership for accountants. Okay. So again, a partnership for the exercise of a profession is not a business. It is not an enterprise for profit. No. The second thing that you have to remember is that the law does not allow individuals to practice a profession as a corporate entity. So I have to emphasize, class, that while the law allows professionals to form a partnership, the law does not allow professionals to practice their profession as a corporation. This is why, class, wala kayong makikitang mga korporasyon ng mga abogado, for example, or korporasyon ng mga certified public accountants, or corporation composed of engineers, class, no? Because technically speaking, no, the law does not allow individuals to practice a profession as a corporate entity. The only corporate vehicle, or rather, the only business entity in which the law allowed the practice of profession is through a sole proprietorship, yan yung mga tinatawag natin ng mga solo practitioners, or a professional partnership. Again, but not as a corporate entity. Now, iisipin natin, bakit kaya hindi hinayaan ng batas na mag-practice ng profession, no, through a corporate entity? Now, you will take note, class, under Section 36 of the Corporation Code, no, nakalagay dyan lahat ng express powers of the corporation. For example, the corporation can own property under its name. The corporation can file a suit and defend its suit under its name. No? A perusal of the express powers of the corporation will yield to a conclusion that the practice of a profession is not one, no, is not one of the express power of the corporation. No? Mapapansin yan if you go over the enumeration of the express powers. Now, what is the reason why a corporation could not practice a particular profession? Now, a corporation could not have personal qualifications required of a professional. No, ang isang korporasyon, because it is a mere artificial being, no, it does not possess certain personal qualifications which is required of a professional. For example, age. No, wala namang, well, pwedeng magkaroon ng age ang isang corporation because of the corporate term. But what about good moral character? No, a corporation does not have a good moral character. It may have a business goodwill, no, but not a good moral character. Another thing that a corporation lacks, no, which disables it to practice a profession, is academic aptitude. No, a corporation, unlike a natural person, does not have an academic aptitude or educational attainment. These are the reasons why a corporation is not allowed by law to practice a profession. Again, only in the form of a sole proprietorship or the solo practitioners or a professional partnership. Now, when does a partnership commence to exist? Nung kailan ba nagkakaroon ng contract of partnership? Now, partnership commences to exist from the moment of the execution of the articles of partnership unless it is otherwise stipulated. Now, sabi natin kanina that a partnership is a contract. Now, this contract, no, or this partnership will begin to exist from the moment that the contract has been executed by the partners. And what do you call this contract? The articles of partnership. No, you will take note in a corporation, you execute articles of incorporation. But in a partnership, the contract is called articles of partnership. Now, once the articles of partnership has been executed by the partners, then partnership commences to exist. Okay. Is there an exception to this general rule? Yes, there is. The articles of partnership itself can provide for a specific date of the commencement of the partnership, which is separate from the date of execution. So, class, pwede yun. Pwedeng ilagay sa articles of partnership. These articles of partnership will commence to exist 6 months after the execution of this agreement. So, inaalaw yan ng batas. But in the absence of a stipulation, then partnership commences from the execution of the articles of partnership. Now, we ask the question, are there formalities required before a contract of partnership is executed? No, meron bang kailangan mga alituntuning sundin para maging valid ang isang contract of partnership? Now, as a general rule, there is no special form required for a contract of partnership to validly exist. No, there is no special form which is required by law for its validity or existence. As a result, a contract for partnership or the articles of partnership may be in oral or verbal or in writing. So walang formalities required. Now, are there exceptions to the general rule? Yes, the answer is yes. There are certain exceptions in which case the articles of partnership must be in writing or in a public instrument class. So, ang general rule, walang formalities na required ang articles of partnership. No, except under these certain circumstances. There are actually two circumstances, no. What is the first exception? Okay, class, naalala nyo nung nag-aral tayo ng obligation and contracts, di ba? Sa Article 1403, you will find there the statute of fraud. Alam ko, naaalala nyo pa yan, di ba? Statute of fraud. Naalala nyo ba, class? Now, if an agreement to enter into a partnership will not be performed within a year from the execution of the contract, that agreement is now covered by the statute of fraud. Kasi naalala nyo, class, pag binalikan yung Article 1403, nakalagay dyan, any acts which is not to be performed within 1 year or within a year from the date of execution of the contract, then it is covered by the statute of fraud. Makikita niyo yan, class, sa contracts. Now, ano ba ang ibig sabihin ng statute of fraud? If a particular contract is covered by the statute of fraud, then such contract must be in writing. Tandaan niyo yan, class. If an agreement is not to be performed within 1 year, such contract is covered by the statute of fraud, in which case the agreement must be in writing. Now, class, the question is, if the contract of partnership or the articles of partnership, which is not to be performed within 1 year from the date of the execution of the contract, has not been complied. Ibig sabihin, hindi in writing yung agreement. Now, what is the status of the articles of partnership? A, valid. B, void. C, voidable. D, unenforceable. Anong sagot? The answer is the agreement which is in oral form is unenforceable. Tandaan yan. Class, you remember our discussion on defective contracts. Sinabi natin that an unenforceable contract is a valid contract except that it may not be enforced in the absence of written instrument or contract. So in other words, even if the articles of partnership is not to be performed within 1 year from the date of execution of the contract, such agreement remains to be valid except that it must be in the written form. Valid pa rin yan, kaya lang hindi siya enforceable. You cannot invoke the performance of the contract in the absence of a written instrument. Okay. Now, the second exception from the general rule, Okay, let us have a recap. Sabi natin kanina, there are no formalities required of a contract of partnership. In other words, kahit anong form, pwede siya. Exception to that is what? Number 1, sabi natin, when an agreement is not to be performed within 1 year from the date of execution of contract, in which case it is covered by the statute of fraud. In other words, it must be in writing. Now, the second exception to this one, class, and I want you to remember this exception, is when real rights or property have been contributed to the partnership regardless of the value. Class, kung ang contribution ng mga partners consists of, for example, an immovable property, for example, lupa, or building, mga immovable or real property, pag yan ang contribution ng mga partners, class, ang sabi ng batas, The contract must be in a public instrument. Anong ibig sabihin niyan, class, in a public instrument? In other words, the contract of partnership must be notarized. Kailangan notaryado, no? If a document or a contract has been notarized, then it becomes a public instrument. Okay, now, sabi dito, aside from the fact or the requirement that it must be in a public instrument, no, the articles of partnership must be signed by the parties and registered in the registry of deeds. These are the three formalities required by law. Ang sabi dyan, number 1, the contract must be in writing. Number 2, the inventory must be signed by the parties, and that such agreement, no, the public instrument or the properties contributed by the partner must be registered in the registry of deeds. These are the three formalities required when the partner have contributed or has contributed real rights or property. Now, class, what is the consequence, for example, if the partners did not comply with the requirements imposed by law? For example, nag-contribute sila ng lupa o ng building, no? Tapos, hindi siya notaryado, the contract of the articles of partnership has not been notarized. And there is the inventory has not been signed by the parties and registered with the RD or the Registry of Deeds. What is the status of the contract of partnership? A, valid. B, voidable. C, unenforceable. D, void. The answer, class, is letter D, void. Tandaan nyo yan, class. When real rights or property has been contributed by the partners, no, the contract must be notarized or in a public document, and that the inventory must be signed by the parties. And number three, that it must be registered with the registry of deeds. All of these requirements must be present. Okay. Okay. Now, class, minsan ang kino-contribute ng mga partners are not real property or hindi real rights, for example. Paano kung ang kinontribute nila ay pera or personal property? For example, class, kotse. Nagbigay sila ng kotse or ng truck. Class, no? So, ang sabi ng batas, if the capital contribution consists of money or personal property amounting to 3,000 pesos or more, 3,000 o higit pa, the contract must be in public instrument and registered with the Securities and Exchange Commission or the SEC. So, class, pag tinanong kayo sa exam kung ano ang formalities na required, depende sa classification ng contribution. If the contribution consists of real rights or property, then you have to comply with 3 requirements. The contract must be in a public instrument, the inventory must be signed by the parties, and it must be registered in the registry of deeds. Now, if the contribution, on the other hand, consists of money or personal property amounting to 3,000 pesos or more. I want to emphasize that, class, 3,000 pesos or more. Kasi minsan nalilito kayo pag sinabing 3,000 sakto, isipin nyo, nako, covered kaya ito ng rule o hindi? Di ba? Tandaan nyo, class, 3,000 pesos or more. Huwag nyo sasabihin more than 3,000 pesos. Pag umabot ng 3,000, meron ka ng formalities na required. Ano yon? The articles of partnership must be in a public instrument and it must be registered. The partnership must be registered with the SEC. Securities and Exchange Commission. Now, class, if in case that the articles of partnership is not in a public instrument or it has not been registered with the SEC. Now, for example, notaryado siya pero hindi mo nirehistro sa SEC. Ang tanong, what is the status of the articles of partnership? A, valid. B, voidable. C, unenforceable. D, void. Yan ang tanong dyan, class. Halimbawa, ang capital contribution is money or property consisting of 3,000 or more. Hindi mo pinanotaryuhan yung articles. Hindi mo rin nirehistro. O kaya halimbawa, pinanotaryuhan mo pero hindi mo pinarehistro sa SEC. What is the status of the articles of partnership? The answer is A, valid. Class, tandaan yan. That is the distinction between non-compliance with contribution of real rights or property on one hand and non-compliance with formalities when the capital contribution is money or personal property amounting to 3,000 or more. Magkaiba ang consequence ng non-compliance. Kung ang hindi mo kinomply, it is with respect to real rights or property, then the articles itself becomes void. Void, void, void. On the other hand, class, if what has been contributed in the partnership consists of money or personal property amounting to 3,000 pesos or more, and you did not comply with the requirements of the law, which is the notarization of the articles of partnership and the registration with the SEC, class, valid pa din ang articles of incorporation. Why? The failure to comply with the requirement in this respect, class, does not render the partnership void. Magkaiba ang consequence kapag ang contribution mo consists of real rights and properties. Doon sa ang capital contribution is consisting of money or personal property amounting to 3,000 pesos or more. Kahit hindi yan naka-public instrument, kahit hindi yan nakarehistro sa SEC, class, valid pa din ang articles of partnership. Because, class, kung ang contribution ng partners are money or personal property amounting to 3,000 pesos or more, registration is not mandatory. Tandaan nyo yan. Registration with the SEC becomes mandatory only if the capital contribution consists of, or if the contribution consists of real rights or real property. Tandaan nyo yan. Okay. Now, let us go to the elements of partnership. No, maraming mga, actually, these are the characteristics of a partnership, class. Number one, consensual. Alam na natin yan, class. Sa law on obligation and contracts. Diba? Pag sinabing consensual, it is perfected by mere consent. Diba? A contract of partnership is a consensual contract. It is perfected by mere consent. It is perfected from the moment that the partners have signed or executed the articles of partnership. Second is that it is a nominate contract because the law gives it a special appellation or special name, class. Number three, it is bilateral in nature because there are reciprocal rights and obligations that are incurred by the partners. Fourth, it is onerous because you have to give something, no? You have to contribute the MPI, money, property, or industry. It is also commutative in the sense that the undertaking of the partners are equal in nature It is also a principal contract, no, as opposed to an accessory contract, because a contract of partnership does not depend on another contract for its existence or validity, rather. Now, a contract of partnership is also a preparatory contract because it is a means to an end. These are self-explanatory. Excuse me. I will leave them to you. Now, let us go on the essential features of a partnership. Class, ito yung mga kailangan bago magkaroon ng partnership. These are the elements of partnership. 1, there must be a valid contract. Number 2, the parties must have legal capacity to enter into the contract. Number 3, there must be mutual contribution of MPI to a common fund. 4th, the object must be lawful. And 5th, the purpose or the primary purpose must be to obtain profits and to divide the same among the parties. Let us go to the first one. Existence of a valid contract, class. Again, you have to refer to the formalities required of a partnership. Go back doon sa diniscuss natin na formalities, no? Always look on the kind of contribution made by the partners, if it is a real property or a personal property or money consisting of 3,000 or more, etc., etc. Now, class, magtatanong kayo, paano kaya yung money which is less than 3,000 pesos? Or for example, a personal property which is less than 3,000 pesos. Hindi siya required to be in writing, no, or in a public instrument rather, and it is also not required to be registered with the SEC, but this will be more on just a theoretical application because wala namang partnership na which is may capital na or assets na less than 3,000. Okay, anyway, the concept here is that there must be a valid contract because it is a contract of partnership is a special species of a contract. So without a valid contract, a partnership may not exist. Okay, class. Itong doctrine of delectus personae, anong ibig sabihin nito, class? Kasi class, ang partnership, no, as compared to a corporation, no, before a partner is admitted to a partnership, pinipili siya. No, kailangan lahat ng partners pumayag na maging partner siya. Iyan ang sinasabi nating delectus personae. The qualities, the personal qualifications, the personal characteristic of a partner is being considered before he is admitted to the partnership. No, a fiduciary relation exists between the partners. Ibig sabihin, class, merong mutual trust and confidence between the partners. Kaya nga, class, pag sinabi ng isang partner, I no longer trust you, no, that can be a ground for expulsion in a partnership because, again, you because of the doctrine of delectus personae, no, a partner is selected, no, or being qualified in accordance with the personal characteristics of the partner. And that there must be a mutual trust and confidence between and among the partners. Now, class, you have here in the screen about a limited partnership. Class, tandaan nyo yan. This is the exception to the rule that a contract of partnership is consensual in nature. When you say consensual, it is perfected by the mere execution of the contract of partnership. Now, exception to this rule is in case of a limited partnership. No? In case of a limited partnership, kailangan may approval ng Securities and Exchange Commission. Kasi class, nire-regulate yung limited partnership. Kasi when you say limited partnership, no, yung mga limited partners, no, are not actually liable, no, beyond the capital contribution in the partnership. Kaya ang limited partnership, class, makikita ninyo yung pangalan nila may nakalagay doon, LTD. No? That means that the SEC requires all limited partnership to indicate that it is a limited partnership to warn the public, no, dealing with the limited partnership, that the partners, no, may not be held liable beyond their capital contributions, no, unlike a general partnership. So since this partnership, no, will have to be dealt with by the general public with caution, no, hindi siya perfected by mere voluntarily or by mere voluntary agreement. No, it must be approved by the SEC first. Okay. Now, these items, no, these two items, no, are not considered as a partnership because they are not created by expressed or implied contract. Kaya nga sabi natin kanina, contract is an essential element or feature of a partnership. Now, in these two items, there is no express or implied contract, which is why it is not considered as a partnership. What are those? Number one, religious societies. For example, class, yung mga Youth for Christ, no? Couple for Christ. These are religious societies. Are they considered as a partnership? Kasi class, may contribution din dyan, di ba? In the form of donation. Di ba? Pag nagbibigay ka ng offering, di ba? Pag nagbibigay ka ng offering mo, is this in the form of a capital contribution or contribution in the form of a money? Class? Answer, no. No? Hindi siya contract of partnership. Kasi walang contract between the religious society and the member or the believer of a particular religious society. So because there is no contract, no, a religious society may not be considered as a partnership. Now, also a conjugal or community partnership, these are the property regimes that govern a husband and wife. Diyan, class, hindi din talaga siya technically or strictly speaking a contract. No, because it is governed by the family code. So in the absence of an express or implied contract, no, you cannot consider it as a partnership as understood by the law. Okay. Now, legal capacity, class, important yan. No, before a contract of partnership can exist, no, the partners must have legal capacity to enter into a contract. Now, class, there are certain persons who cannot give consent. In other words, they cannot enter into a contract. If they cannot enter into a contract, definitely they cannot form a partnership. Who are these? Minors, no, insane, demented persons, deaf mutes who do not know how to read and write, persons suffering from civil interdiction. Class, anong ibig sabihin ng civil interdiction? Class, a civil interdiction is an accessory penalty imposed to a person or to the accused, no? If the imprisonment consists of more than 6 years. Yan yung mga nakakasuhan class ng criminal cases. Pag na-convict sila and the penalty of imprisonment consists of more than 6 years, which means 6 years and 1 day or above, then meron siyang accessory penalty ng civil interdiction. Ibig sabihin, hindi niya pwedeng i-dispose lahat ng property niya. Now, if a person is suffering from civil interdiction, he cannot join a partnership because he cannot dispose his property. Hindi siya pwedeng magkaroon ng capital contribution or any contribution of any sort. Because again, as a result of his conviction of a crime, no, which is punishable or punished by imprisonment consisting of more than 6 years, hindi siya pwedeng mag-dispose ng property and therefore he cannot contribute money or property. Okay? Now, incompetents who are under guardianship. Ito class yung may mga, for example, if the mental age of a person is 16 years old or 12 years old, okay? Although by age 18 na sila, no? Yung kanilang mental maturity is way below their biological age, they are also disqualified, no, to form a partnership. Okay. Now, class, a partnership can be a partner in another partnership. For example, partnership ka na, for example, SGV, no, a very famous accounting firm, no, pwede siyang maging partner in another partnership. Ibig sabihin, yung SGV as an accounting firm can join another partnership or group of partnership. On the other hand, class, a corporation cannot enter into a contract of partnership. Ano ibig sabihin natin dito, class? Pag partnership ka, pwede kang maging partner sa ibang partnership. Ha, tandaan niya na, class, ha? A partnership can join another partnership, but a corporation cannot enter into a contract of partnership. Pag isa kang korporasyon, hindi ka pwedeng pumasok sa isang contract of partnership. For example, ABC Corporation, no? Hindi siya pwedeng pumasok sa contract of partnership. Why? Class, kasi sabi natin sa corporation code, no? The corporation can only be governed by the board of directors or any authorized representative. Kaya nga, class, kapag may corporation, nag-e-execute ang corporate secretary ng secretary certificate, no? Or ang board of directors nagka-come up with the board resolution to designate a specific person who will act as the corporation's representative. Because, class, a corporation should only be governed by the board or by its authorized representative. Now, if a corporation will join a partnership, hindi na siya, no, the corporation will be bound by the acts of the partners. And these partners are not the duly authorized representative of the corporation. That is why a corporation, no, may not enter into a contract of partnership. Kasi otherwise, no, it will run afoul. It will violate the principle that the corporation should manage its own affairs separately and exclusively. Okay. Now, class, let us talk about the contribution of a partner to a common fund. What are the properties that a partner can contribute to the assets of the partnership? Number one, it can be real or personal. No? Sinabi natin kanina, real rights, real property, or it can be a personal property, a movable property just like a car, a cell phone, no? Or jewelries, for example. It can be tangible or intangible. When you say intangible, class, yung hindi nahahawakan. Okay. Now, what are examples of intangible properties that can be contributed by a partner? Credit, class. For example, a promissory note, no, which is an example of a negotiable instrument. A promissory note, class, is an example of an intangible asset or property. Bakit natin tinawag na intangible? Kasi, class, although mahahawakan mo yung promissory note, actually what is being contributed through a promissory note is not the piece of paper itself, but the credit which is evidenced by the promissory note. Kaya ang promissory note, class, is considered by law as an intangible property or an intangible asset. Hindi siya nahahawakan, class. Baka magsabihin nyo, yung promissory note naman, sir, nahahawakan, di ba? The promissory note is not the credit itself, but only an evidence of credit. It is a mere evidence of the obligation, no? Or for example, class, goodwill of a business, it is also considered as an intangible property. Now, any kind of industry can be contributed to a partnership. For example, class, secretarial services, or kung accountant kayo, yung accounting services o auditing services. If you are a lawyer, then you can offer your service as a counsel, no, legal services, retainer services, etc., etc. These are labor or services that you can contribute as an industrial partner. Pero tandaan nyo, class, when you are a limited partner, you cannot contribute mere industry or services. Kapag limited partner ka, class, ang pwede mo lang i-contribute is cash, money, or property. No, take note of that. Now, if the object of the partnership is against the law, for example, class, nagbuo kayo ng partnership ng ang ititinda ninyo are contraband, no? Yung mga pinagbabawal ng batas, no? Hindi pwedeng ibenta, for example, yung mga wildlife, yung mga animals, no, na kinukuha sa forest, or for example, class, yung mga plantito-plantita, di ba? Sabi ng DENR, there are certain kinds of plants which may not be poached. Pag yan ang ibinenta nyo, class, or if the object of partnership is the poaching of mga plantitas, ang mga halaman, no, the object, no, of the partnership is against the law. So the partnership becomes void ab initio, or void from the beginning. So class, the object of partnership must be lawful. Now, class, there are certain kinds of business that the partnership may not engage itself with. No, as a general rule, lahat ng business pwedeng pasukin ng partnership except those businesses which the law requires another form of business entity. For example, class, the banking business. No, ang sabi ng batas, class, the General Banking Law or the General Banking Act, no, sabi ng batas, only corporations may engage into the banking business. So bawal din ng sole proprietorship. Kaya class, wala kayong makikitang sole proprietor na bangko. Wala rin kayong makikitang bangko na partnership, no? Only corporations can engage into the banking business because it is required by law. Actually, class, if you will be technical about it, the Philippine Cooperative Code of 2008 likewise allows a cooperative to engage into the banking business as long as license or permit has been issued by the BSP. Okay. Now, class, the most important feature of a partnership is the intention to realize and divide the profits. This feature is what distinguishes a contract of partnership with other contract. No, nag-contribute ka ng money, property, or industry, no, and then mag-e-engage yung partnership into a business transaction, and whatever yield or profit the partnership makes, no, will be divided between and among the partners. This is this essential feature of the partnership which makes it different from other contracts. Now, class, for example, hindi kumita yung partnership or the partnership has engaged in an unprofitable business. Can it still be considered as a valid partnership? No, walang kinita or unprofitable yung business niya. Is it still a valid partnership? Answer, yes. Kasi class, the law requires only intention to realize and divide the profits. The law does not require that the partnership will actually reap some profits. The partnership need not reap actual benefits or profits or income before it can be considered as a partnership. No? Suffice it to say that there is an intention among the partners to realize and divide the profits. Okay. Now, class, if a partner receives a share in the profits, no, if a person receives a share in the profits, may natanggap siyang kita nung isang business endeavor, this is already a prima facie evidence that there is a partnership and that he is a partner to such business. So pag nakatanggap ka ng profit sa partnership class, parang ebidensya na yan na isa kang partner ng partnership na yon. Now, there are certain exceptions to the general rule. Which means, class, that even if you have received profit from the partnership, no, hindi ka pa rin nagiging partner kahit makatanggap ka ng profit. Ha? These are the instances, for example, class, binayaran, may utang sa'yo ang partnership. Nag-issue ng cheque, for example, promissory note, no? Because the partnership, for example, ordered for a specific products that the partnership sold, no? So, babayaran ka ng partnership or for the payment of a debt, umutang sa'yo, if a partnership obtained a loan from a specific person, the payment of such loan does not convert the creditor as a partner in the partnership. Because the intention there, the payment there is to extinguish the obligation and not in the form of contribution of money or property. Now, class, pag binayaran ka naman, pinasweldo ka, no, as an employee. No, kasi magkaiba yung partner sa employee class eh. Kasi ang partner, the partner will have to share in the profits and losses. Pag nalugi ang partnership, wala siyang sweldo. No? Pero ang empleyado, as long as nagtrabaho siya, meron siyang sweldo. Now, if an employee receives wages from the partnership, then he does not become a partner. Because the payment of wage is different from receiving a profit of the corporation. Etc., etc. Class, you just have to read to go over the exceptions. They are self-explanatory. No, annuity, interest, or consideration for the sale of goodwill of a business, etc. Okay. Now, class, to end this video, we will distinguish partnership from co-ownership. Class, ano ba yung co-ownership? There is co-ownership whenever ownership of an undivided thing or right belongs to different persons. Class, halimbawa, X and Y are spouses, tapos namatay sila, meron silang children, A, B, C. Now, class, kapag na-inherit ni A, B, C, for example, yung house and lot ng parents nila at hindi pa nila pinaparte yung kanilang mana, merong co-ownership. No, because co-ownership is when there is an undivided thing, no, and that thing belongs to a different or to different persons. Magkakaiba ang may-ari. Okay. Let us compare partnership and co-ownership. Now, class, partnership is created by agreement of the parties. No? Partnership is created by the articles of partnership. On the other hand, co-ownership, class, does not need a contract to exist because co-ownership is created by operation of law. Dun sa example ko kanina, pag minana ni ABC yung house and lot ng parents niya, they need not execute a contract for co-ownership to exist. Because co-ownership exists by operation of law. Tandaan niya, class, ano yung batas na tinatawag dyan? When you say by operation of law, by the death of the person, no, the properties, rights, and obligation of a person is transmitted to his or her heirs. Ito yung sinasabi nating by operation or by provision of the law. Now, a partnership has a juridical personality, just like a corporation. On the other hand, a co-ownership has no juridical personality. Now, the purpose of partnership is for the realization and division of profits. But on the other hand, a co-ownership is for the purpose of common enjoyment of a thing or right? Now, when it comes to duration, class, ang partnership wala siyang specific duration or walang prohibition by law for it to exist, for example, for a period of 5 years. There is no such limitation. On the other hand, class, a co-ownership can only last for 10 years. No, if the co-ownership would exceed 10 years, then it will not be allowed by law. Disposal of interest. A partner may dispose individual interest to its assignee, no? But in co-ownership, you can dispose your interest. Class, for example, partner ka sa isang law firm or sa isang accounting firm, hindi mo pwedeng ipamana sa mga anak mo yung membership mo sa isang partnership. Why? Because in a partnership, the personal qualifications of a partner is being taken into consideration. Kaya nga tinatawag na delectus personae. You are chosen by the partners because of your personal qualifications, which is why you cannot freely dispose your interest in a partnership if you are a partner. On the other hand, if you are a mere co-owner in a co-ownership, you can freely dispose your interest in the co-ownership. It means that you can transfer your ownership or your interest to another person without the approval of the other co-owners. Kahit hindi pumayag yung ibang co-owner, class, pwede mong i-transfer yung interest mo sa co-ownership. But that concept is not true with respect to partnership. Kasi again, class, all partners must agree, no, for a person to be admitted in a partnership. Okay. Power to act with third persons. Class, lahat ng partner ay ahente o representative ng partnership. No? On the other hand, a co-owner is not or does not have the power to act with third persons. Now, death of a partner dissolves partnership, but death of a co-owner does not dissolve the partnership. Why? Because a co-owner can freely dispose his interest in the co-ownership. Kaya class, sa partnership, pag namatay ang isang partner, na di-dissolve yung partnership. Why? Because the heirs may not be automatically admitted. No, the heirs of a deceased partner may not be automatically admitted in the partnership without the approval of all the partners. Okay. How about the distinction between a partnership and a conjugal partnership of gains? Class, yung conjugal partnership of gains is a property regime which governs certain spouses. No, depende sa choice nila or depende sa year of the celebration of the marriage. No? The parties in a partnership can either be male or female, but the party in a conjugal partnership of gains must be male and female or future spouses. Okay. Now, a partnership is governed by the new civil code, while the conjugal partnership of gains is governed by the family code of the Philippines. And the third, a partnership has a juridical personality, while a conjugal partnership of gains has no juridical personality. Now, commencement of a partnership from the moment of execution of the contract. On the other hand, class, a conjugal partnership of gains commences from the very day or the very time that the marriage is celebrated. Any stipulation to such of other commencement of effectivity will be void. Will be void. Now, in a partnership, the purpose is to obtain profits, but in a conjugal partnership of gains, the purpose is to regulate the property relations of the spouses. Kasi class, pag conjugal partnership of gains, no, if the property regime is CPG, no, this will govern whether the property is a separate property or individual property or forming part of the conjugal partnership of gains. So the purpose of CPG is not to obtain profits, but to determine which of the property is separate property and which of the property is forming part of the conjugal partnership of gains. Now, class, in partnership, no, ang distribution ng profit is usually according to the according to the contribution made by the partner. No, in CPG, hindi the distribution of profits, for example, between the husband and wife is always and always equally. It does not depend on the contribution of the husband or the wife. No, ang sabi ng batas, if a marriage is dissolved, then the conjugal partnership of gains, no, will be divided equally, no, not according to the agreement, not according to the contribution. Management. In a partnership, no, every partner will have to manage the partnership. So pagka husband and wife class, actually ang sabi ng batas, the affairs, no, in the family will have to be shouldered both by husband and wife, no, but when it comes to a question in the administration of the household, the husband's decision will prevail. Yan ang nakalagay sa civil code. Now, distribution of shares in case of conflict lang naman. In case of conflict. Now, distribution of shares. In partnership, no, interest may be disposed without the consent of other partners. On the other hand, class, in a conjugal partnership of gains, you cannot dispose your property during marriage without the consent of your spouse, if the property is conjugal in nature. But if it is your personal property, then you can dispose it even without the consent of your husband. Which is why, class, makikita nyo sa mga contracts, kapag married na yung isang tao, tapos nagbebenta siya ng lupa, nakalagay palagi doon sa deed of sale or contract of sale with marital consent. Nakalagay. Or kung wala yung marital consent, nakalagay doon yung pangalan ng spouse. Kasi class, if the property belongs to the conjugal partnership of gains, then the consent of the spouse must be obtained by the selling spouse. Okay, class, this ends the first topic for this afternoon. See you on the next video.